Let me tell you about a good friend of mine, a client, young guy, is out driving one night coming from a house party. He's got a nice muscle car and just lost control, trying to make a U-turn, and his tires ran off the roadway just a little bit, but it was steep enough to pull his car off the road and into a ditch. The cops show up, they interview him, and all they really observe is that he was a little unsteady on his feet. He told them he was coming from a party. Now, the officer who was investigating the case was almost brand new to law enforcement. He was a trainee and had a supervisor there to help him out throughout the entire investigation. Well, the trainee told his supervisor that the only thing he observed was my client being unsteady on his feet, being involved with the accident, and the admission to having come from a party. There was no evidence that he had any odor of alcohol coming from his breath or person, and my client never admitted to drinking. So the police continue their investigation, and they ultimately have my client do some field sobriety tests, and they get my client to agree to a breath test at the police station on the Intoxilyzer 9000. Those results were about 0.12 above the legal limit. So client hires me, we go to court, and we get it scheduled for a motion to suppress. That's where I get to make legal arguments to a judge about why certain evidence could not be used against him. And the objective was to get those breath test results thrown out. So we're there for motions. The first officer, being the trainee, testifies. And I cross-examine the officer and elicit that he never got any evidence beyond those three things before continuing into a new DUI investigation. So we conclude the hearing and I make my arguments to the judge. One of the issues that I raised was that the police had no evidence that was separate and apart from the initial traffic investigation, being a car accident, to justify continuing to detain my client into a new separate DUI. Now, what's the most common thing that we think of that transforms a regular traffic case into a DUI? It's the odor of alcohol. But the officer even said on video he never detected the odor of alcohol at that point in time. The judge agreed and suppressed every single piece of evidence from the moment that that officer told my client to walk towards his patrol car and then started this new DUI investigation. All of his statements, all of his field sobriety tests, and that breath test result got kicked out, and the prosecutor agreed to resolve the case to one count of failing to maintain lane, pay a $200 fine, case closed. In the next video, I'm going to tell you a story about another client where we got their DUI charge reduced to failing to remove a vehicle from the roadway.